Pretrial fairness portion of the Safety Act set to drop Monday. Lawyers in the land of Lincoln could get a whole lot busier. 23 News reporter Connor Hollingsworth talks with lawyers across the region about whether their office will see an increase in workload.
There are multiple factors with pretrial fairness that could cause lawyers to be busier in the state line. Time will be of the essence when a person is arrested and if they have to go to trial. While some are worried about the increase in workload, others say the key to staying ahead is making the necessary preparations.
All of this really has affected the criminal justice system, whether it's our office, the public defender's office, the clerk's office, the judiciary.
Under the pretrial fairness portion of the law, those accused of significant offences must appear in court within 48 hours after arrest. Winnebago County State's Attorney Jay Hanley says those hearings will be different.
There's a lot more work that will have to be done. We'll have to determine whether someone's detainable and then whether we're going to file a petition to detain.
Starting September 18th, anyone currently in custody on bond can choose to be treated under the new law.
Defense attorneys are going to have to go meet with their clients, have those discussions, and potentially file those motions.
Some local defense attorneys aren't worried about the changes.
I don't really see an increase in our workload.
The reality is most people who get detained under the current system, there's going to be hearings anyway.
Chris Durango with Durango and Kane says Saturday court already happens in the 17th Judicial Circuit.
In our criminal division here, we have 4 attorneys, myself included. So what we will do is we'll divide up. Each of us is going to have a weekend every month that if we get retained by a new client and they have Saturday court, it's going to be you.
But attorney Jonathan James admits other offices could see an increase in workload.
I do think it's going to be a significant increase for the workload at the public defender's office who, can be appointed even for defendants who usually aren't eligible for the public defender for the exclusive purpose of that detention hearing.
Now, we did reach out to Nick Zimmerman with the public defender's office, but he was unavailable for comment today. But Hanley did say his office is in the process of hiring more attorneys to help alleviate that workload.
Hanley also worries about the 90-day rule. If a person has committed a detainable crime, prosecutors need to have trial ready in 90 days, which Hanley says is nearly impossible. But since this portion of the law isn't even out yet, he says time will only tell.